This is a critical analysis of court-ordered mental health therapy in Utah family law. In family law proceedings in Utah, particularly those involving child custody disputes, courts frequently order parents and children to engage in mental health therapy of one kind or another. While the ostensible intent behind these orders is often to promote family or individual well-being and mitigate emotional harm, these orders often suffer from procedural, evidentiary, ethical, and other defects, often significant defects. I will mention other defects in a second video on this subject, but I'm going to talk about those generally that can undermine both therapeutic efficacy and the rights of family members. Too often, therapy is ordered without a sufficient evidentiary basis demonstrating its necessity, the scientific validity of the specific therapy chosen, or clear guidelines for its termination. This practice can lead to unintended consequences, including unnecessary financial burdens, infringements on parental rights, and even potential psychological harm. Let's talk about insufficient evidentiary bases. One of the most troubling aspects of court-ordered therapy in divorce cases and child custody disputes is the frequent lack of evidence demonstrating that therapy is necessary. In many cases, therapy is imposed based on vague allegations of emotional distress or parental conflict, or a judge's subjective determination, rather than clear, objective evidence of psychological or other harm. This practice contradicts fundamental legal principles requiring judicial decisions to be based on factual findings and substantiated evidence. Courts often rely on the recommendations of guardians ad litem, custody evaluators, and mental health professionals without requiring a rigorous, objectively verifiable evidentiary showing that therapy is necessary or warranted. Consequently, judges often order therapy based on recommendations from professionals or so-called professionals who may have biases, financial interests, or affiliations with controversial treatment methodologies. Many court orders for therapy stem from allegations rather than proven facts. A parent might claim the other suffers from anger issues or parenting deficiencies or is violent, and without thorough analysis, evaluation, lazy and/or virtue signaling courts may order therapy as a precautionary measure. This approach treats therapy as a harmless intervention rather than recognizing it as a significant imposition requiring justification before a court can order it. Courts often erroneously apply a substantially lower evidentiary standard to therapy orders than is required for other court interventions. Therapy orders frequently result from mere allegations or the recommendation of court-appointed evaluators whose assessments are often cursory, subjective, and biased, and pseudoscientific. In some instances, therapy is ordered simply because one party requests it, despite the absence of documented mental health concerns or expert testimony supporting the need for intervention. This practice can lead to an overreach of judicial authority, imposing significant obligations on parties and their children without proper justification. Furthermore, the stigma associated with mandatory therapy can unfairly prejudice the court against the ordered party, potentially influencing future custody determinations and other legal outcomes. Let's talk about the lack of scientific validity in prescribed treatments. When courts order therapy, they rarely assess whether the specific therapeutic approach prescribed meets established standards of scientific validity. They seldom distinguish between evidence-based modalities, like cognitive behavior therapy, and less validated approaches. Others often state simply that one must attend therapy or counseling without specifying the type of treatment or requiring it to meet scientific standards or achieve specific outcomes. These oversights can lead and often do lead to ineffective or potentially harmful interventions. The qualifications of providers are frequently overlooked as well. Court orders may not specify that therapy must be provided by licensed practitioners with appropriate expertise in the relevant issues, potentially exposing parents and children to unqualified or inappropriate treatment. Let's talk about absence of clear goals and termination criteria. Court orders for therapy frequently lack specific goals and termination criteria, potentially subjecting parents and children to indefinite treatment with no clear path to completion. This indeterminacy can create situations where therapy becomes punitive rather than rehabilitative, or even counterproductive, with parents and children unable to satisfy vague or shifting expectations. This lack of direction creates a system where therapy can become a tool of control and oppression rather than a means of progress and healing. The absence of termination criteria also grants excessive discretion to therapists who may become de facto judicial decision makers, determining when a parent has successfully completed treatment, even though it's a subjective call. This delegation of judicial authority raises serious due process concerns, particularly when therapists' recommendations directly impact the fundamental rights of parents and children. Without the court clearly defining goals, what constitutes attaining those goals, and a structured evaluation process, court-ordered therapy can become a prolonged, intrusive, and financial burden, rather than a targeted intervention designed to resolve specific issues as soon as possible. Let's talk about better practices for court-ordered therapy. To address the issues I've discussed here, courts should adopt more rigorous standards for ordering mental health therapy and take a more surgical approach. Number one, first consider alternative approaches to therapeutic intervention, such as educational parenting programs with clear curricula and completion criteria, or co-parenting coordination services that focus specifically on improving parental communication rather than attempting to fix perceived psychological issues. Two, require substantial, credible evidence demonstrating the necessity of therapy or counseling, ideally through comprehensive psychological evaluations based upon scientifically sound principles and conducted by qualified professionals. 3. Specify the evidence. Use specific evidence-based therapeutic approaches appropriate to identified issues. 4. Establish clear, measurable, reasonable goals for therapy and explicit criteria for its successful completion, if you find it's necessary to order therapy. 5. Set reasonable time frames for therapeutic intervention with periodic judicial review. And 6. Ensure therapeutic interventions are proportional to the issues identified and the least restrictive means to address legitimate concerns. While mental health therapy can, and in some cases may, help family members, individually and/or collectively, to resolve divorce and custody disputes and their adverse effects, its current implementation in family courts in Utah far too often falls short of basic standards for evidence, scientific validity, and procedural fairness. By adopting more rigorous standards for ordering therapy, courts can better balance the potential benefits of therapeutic intervention with the protection of parents' and children's rights and parental and child autonomy. Final thoughts? Divorce attorneys and litigants should be vigilant in challenging vague or unfounded therapy orders and advocating for a higher evidentiary threshold in such decisions. By doing so, they can help ensure that court-ordered therapy serves both a legal and truly beneficial purpose rather than becoming a tool for judicial overreach and unnecessary intervention in family life.